Welcome, 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 welcome. Today is Judge Vonda Bailey, and let's get started with Judge Bailey. Make this bigger, and let's get started with this.
Anyone who's going to participate in the hearing today has to have their screens on, where their camera's on, and if they don't, I have no choice but to remove them from the hearing.
Matt, can you call the client and see if that's them?
Yes, I will. Judge, I just called my client. I think he's trying to switch the camera back on. He's sitting there. He'll be on in a second.
Okay, I see your client. Your client is the he was the Max Pro, right?
Right, and he's restarting the Zoom because it wouldn't let him turn his camera on.
Okay, it's just someone on the screen now that just says iPhone. I'm just trying to figure out who that is.
And Your Honor, I just saw that you hopped on to YouTube Live. I will exit the meeting and just view from there.
Okay,
Thank you, Your Honor.
You're welcome. Good to see you.
Yes, ma'am. Thank you.
That's the Williams lawyer. Oh, on the other side. Long.
Okay, Your Honor, that may not be our client.
Okay, so I'm just going to remove them from the hearing. They can watch on YouTube.
I don't have, they're not on anybody's witness or exhibit or witness list, Your Honor. They just wanted to, I guess, watch the sausage be made.
Okay, yeah, well, we're streaming live on YouTube in accordance with the Texas Open Courts Act, as well as the courtroom being open. So anyone on the 255th YouTube channel can watch it live. Okay. So all sides ready to proceed?
Yes, ma'am.
Okay, so you all are set for an hour total. The interveners, I split the time up with the hour.
An hour, Judge?
Yes, that's the setting. You all are set for an hour.
Okay, can you?
Counsel, I'm speaking. You all are set for an hour total, and all three sides has to have equal time. So everyone gets 20 minutes aside. The only issue that's before the court is what was spoken about with the Court of Appeals, and that is the property division. All right. So we're on the record in cause number DF 2004783. Counsels, will you please announce for the record?
Bob Emerson representing petitioner Quifam, who is also present.
Thank you.
Good morning, Your Honor. Stephen Davis representing the interveners, Ted and Ann Casales.
Thank you.
Cynthia Willen Allen representing Train Lee. She's the ex-wife or ex-spouse.
Okay, thank you. All right, so you're set at 20 minutes aside. This will include any opening and closing should you choose to give, as well as examination. And I believe, Attorney Emerson, you're the movant. Is that correct?
Oh, we're petitioners. Yes, ma'am.
Okay. All right. You may make an opening statement if you choose to make one.
Thank you. May it please the court, just very briefly. And I apologize if I start talking too fast, given our short time. Please, court reporter, yell at me. As a summary of requested relief, we've listed it as Exhibit 1, but it's there as a courtesy to the court. It lists everything we're asking for. Basically, our perception of this case is that everything is has already been determined, with the exception of the property division. And the property division is limited to the confines of the property that has already been characterized in the final decree of divorce. Pursuant to that, we have provided in our summary of requested relief two separate proposed property divisions. One is based on Mr. Pham's number, one is based on Ms. Lay's numbers. And frankly, we are going to be asking that one or the other be entered. We're kind of okay with either of them. It's, just what the court finds to be, a just and right division. With regard to the contested issue, you probably reviewed a trial brief filed by interveners. It has to do with the Lamborghini. I just want to draw you specifically to the language of the final decree of divorce. The Lamborghini, and that's all it's ever called, the Lamborghini is not characterized as community property in the final decree of divorce. It's in an other provision, which is categorically the same as the spousal maintenance provisions. And we all know spousal maintenance is not a community property. And as such, the discussion of of the Lamborghini will be objecting to relevance heavily because it has not been characterized as community property. And we aren't here on further characterization. You're going to see the same thing in a bunch of Ms. Lay's exhibits. The other thing you're going to see procedurally is Ms. Lay failed to turn over any documents with updated values by the 30-day deadline as mandated in your pretrial order. They've submitted some extra exhibits as of last night. None of those were turned over either. So you're going to see a bunch of objections coming from our side, and we just ask for your patience. But overall, we're asking that the court divide only the property that's listed in the decree, and only divide property. And that does not include the Lamborghini that has been pleaded and briefed by interveners. Pass.
Thank you.
That's my opening. Thank you.
Thank you. Attorney Allen?
Yes, Your Honor, I'll waive opening.
Okay. Attorney Davis?
Yes, Your Honor, very briefly. The decree states, number one, that the Lamborghini was purchased with community assets. The Court of Appeals affirmed that decision. I'm here for one reason only, and that is we have a judgment against QueFam, as you can see from our trial briefing. I have two exhibits, a copy of the original lawsuit, which is a certified copy and therefore self-authenticating and admissible, and a certified copy of the judgment showing that the judgment is for torts, meaning that the community estate of both parties is subject to satisfaction of the judgment. As you know, the 95th Court of Appeals asked me to come intervene in this case because I was trying to collect up there. The characterization of the Lamborghini is not before this court. And if you look at the Court of Appeals mandate, it's pretty clear about that. If the plaintiff wanted to argue about how the Lamborghini was treated, they needed to file an appeal to the Supreme Court based on the Court of Appeals ruling. The Court of Appeals opinion explicitly states that the husband did not present any documentary evidence to support his claim that he did not purchase or own the Lamborghini. And if you go into the bottom of the opinion, the only thing that was reversed is spousal support, which I don't care about, and an issue regarding a GMC Sierra, which I don't care about. The main thing I would like to tell the court is I have a judgment for, as of today, $851,000 for fraud that there has been no attempt to satisfy or any attempt made to resolve that. And I believe that the interveners pursuant to the property code are entitled to all non-exempt assets in the community estate. And that includes the Lamborghini. And so we would ask that any non-exempt assets, and under the property code, Your Honor, because these individuals are getting divorced, they're each entitled to $50,000 in exempt assets. There is a Ferrari listed in Mr. Pham's inventory. There is the Lamborghini, and both of those items should be turned over to the interveners to sell to satisfy the judgment or to offset the judgment, because even a Lamborghini and a Ferrari will not sell for enough money to satisfy a judgment that is $851,000. Thank you.
Thank you. All right. Attorney Emerson, you may call your first witness. Oh, you're on mute, Attorney Emerson.
Sorry, I'd like to call petitioner QueFam.
Okay. Would all those who intend to testify, please raise your right hand. All right. Raise your right hand. Oh, thank you. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, sir. Yes.
Ma'am, I didn't get your answer.
Yes.
Thank you. Attorney Emerson, you may proceed.
Thank you so much. Please state your full name for the court.
Kui Pham.
Okay. And you were the petitioner in this divorce matter, correct?
Yes.
Judge, we'd like to ask that you take judicial notice of the final decree of divorce entered by this court in October 19th, 2021.
The court takes judicial notice of the divorce decree entered on October 19, 2021.
Mr. Pham, I'd like to draw your attention to our Exhibit 1. Is this a summary of the relief you were requesting of the court today, provided as an aid to the court?
Correct. Yes.
And it has two separate proposed property divisions attached to it.
Correct.
And we've also listed those as Exhibits 23 and 24, correct?
Correct.
I'd like to offer husband's Exhibit 1.
Okay, any objection?
I object, Your Honor. It's a summary that he hasn't testified about, and that's not evidence.
Okay, any other objections? Attorney Allen?
No,
Okay. Overrule, husband's Exhibit 1 is admitted.
Thank you, Judge. Of these two proposals, does one of them contain the numbers you provided on a sworn inventory and appraisement?
Yes, sir.
And if you look at Exhibit 20, is that a sworn inventory and appraisement that you filed with this court?
Yes, sir.
That's the spreadsheet that was attached to your sworn inventory and appraisement?
Yes, sir.
If I were to go line by line down each and every one of these, is this a true and accurate listing of the pieces of community property that are listed in the final decree of divorce and your valuations of them?
Yes, sir.
I'd like to offer husband's Exhibit 20.
Any objection?
objection, Your Honor, to his number 20. In the event that he has listed liabilities, he's not put a value to it, either to husband or wife. So it's incomplete. It's confusing.
Okay, any other objections?
No, Your Honor.
Okay, overruled. Husband's Exhibit 20 is admitted.
Mr. Pham, going through this, the property values based on the columns after the value division are for who's in, which person's possession they are in, correct?
Correct, sir.
And if we look at your ex-wife having the house, the timeshare, her retirement, the Ferrari, and all the cash values of life insurance and a secondary business, that gives her 177% of the estate.
Correct, sir.
Okay, and the reason the liabilities listed at the top, those were found in the decree, correct?
Correct, sir.
At the time of final trial, was it your understanding that those had already been paid in full?
Yes.
And those have been paid?
Objection, Your Honor, his witness. Objection, Your Honor, he's leading and testifying for his witness.
Sustained, don't lead.
Thank you. Had those, at the time of final trial, did those credit card obligations, were they still owed?
No, sir.
Okay. And your valuation for the residence is 1.12 million?
Correct, sir.
Okay. Is your number for the Casalis's judgment found on this spreadsheet?
Correct.
And you got that off of the lot? Where did you get that?
Off the case.
The lawsuit they filed to collect?
Yes, sir.
Okay. Now, very briefly, you put on here that the cash value of the insurance policy in your name is in your wife's possession. Why is that?
She's the one that set up all the account for me.
Is it your understanding that she's already cashed that out?
Yes.
Okay. But do you know anything about where those funds have gone?
No, sir.
Okay. I would like to show you what has been marked as Husband's Exhibit 18. This is the proposed property division based on that same inventory that goes with Exhibit 24, which was attached to the summary of requested relief, correct?
Correct.
Okay, I'd like to offer Husband's Exhibit 18 as a summary of his request for property division.
All right, any objection?
No objection at this time, Your Honor.
Okay,
No, Your Honor.
all right. Husband's Exhibit 18 is admitted.
And now, Mr. Pham, I'd like to draw your attention to Husband's Exhibit 19. Is this the same thing where it's a summary of your proposed property division using Miss Lay's values?
Correct, sir.
I'd like to offer Husband's Exhibit 19 as a summary of Exhibit 23, which is attached to the summary of requested relief.
Okay, any objection?
Judge, I don't object to this, but I do object to misstatements of facts in it. So I do that on cross-examination.
Okay,
I'm
Attorney,
not trying to work numbers.
Your Honor, I object to the fact that it's a summary and it's not a summary of his testimony. Apparently, it's a summary of the wife's information, and I don't think that's proper. I think it's hearsay.
okay. Objections overruled. Exhibit 23 is admitted as a summary.
Thank you. Mr. Pham, have you ever purchased a Lamborghini?
No, sir.
Have you ever owned one?
No, sir.
Into this line of person has not been relevant, Your Honor.
I
It's
second
already
that
been
objection, Your
determined.
Honor.
Hold on one second. Attorney Allen, I didn't get your full objection.
I object to this testimony as being not relevant. It's already been determined by the Court of Appeals that it's community property.
And
Attorney Davis?
I further object on relevance and the fact that it's the law of the case regarding the treatment of the Lamborghini, Your Honor. It is not before the court.
may I respond, Judge?
Go ahead.
Very briefly, so if the court does take the posture that the section for other debt is a categorization of community property, the court is limited by the language of the decree, which says the Lamborghini. It never describes whose possession it is in. And so I'm just doing this to elucidate whether or not the Lamborghini everyone has their laser focus on here is the Lamborghini referred to in the decree.
Overrule you, I'll allow it.
Has your name ever been on the title of Lamborghini, sir?
No, sir.
Are you aware of a Lamborghini owned by your ex-wife while you were married?
Yes.
I'd like to show you what has been marked as Exhibit 14. Is this a true and accurate copy of the Department of Motor Vehicles public information request of the title history from a Lamborghini purchased by your now current wife while you were still dating her?
Correct.
Okay, and we have the judge. I'd like to offer Husband's Exhibit 14. The business records affidavit has been on file with the court for 14 days, and documents were provided 30 days out.
Okay. Attorney Allen, what's your objection?
He said that it's been on record for 14 days.
He said it.
No, it's two different things, Judge. Number 14. The business record affidavit is only to 6 pages, 320 through 325. And this is talking about the Department of Motor Vehicles. So I object that he wants to introduce 14, but that's not what his business record affidavit is.
May I respond, Judge?
Not entirely. So it's extraneous documents attached that's not in the affidavit.
May I respond, Judge?
Well,
And I object to pieces.
before you respond, Attorney Davis, do you have an objection?
Yes, Your Honor, just to the point that it is a Texas motor vehicle record. It is not a business record of qui fam. So therefore, the fact that it is been on file for 14 days doesn't make it his business record. And I don't think that the cover page provided by the Texas Department of Motor Vehicles qualifies it as a business record. You can get certified copies of documents from the Texas Department of Motor Vehicles, and that's not what these are by my review.
May I respond, Judge?
Yes.
These are certified copies from the Texas Department of Motor Vehicle. I did belt and suspenders here. This technically falls under the exception of hearsay 803 subsection 6, which is a regularly conducted activity. Number one, it also falls under 803.8, which is a public record, or 803.10, which is the absence of a public record. In other words, I'm showing that the Miss Lay and Mr. Pham never owned this. Additionally, it's 803.14, document affecting interest in property, and it's a business record of the Department of Motor Vehicles. So essentially, I followed literally all of the prongs of the hearsay exception in the Texas Rules of Evidence.
Objections overruled. Exhibit 14, counsel,
Yes, ma'am.
submitted.
Okay, and sir, this is the printout from the Department of Motor Vehicles for all owners of the Lamborghini that is listed in the intervener's brief and request of this court, correct?
Objection, Your Honor. He can't testify about somebody else's documents. The documents either speak for themselves or they don't.
Response?
He's a party to this suit. He's reviewed their pleading against him. The idea that he's not aware of the pleading against him is, I think, frankly, a little inflammatory, but also unfounded, and that isn't a real objection.
Okay, and the court's position is that his testimony regarding an interest in property would fall under 804.13. So the objection is overruled. You may continue.
So, Mr. Pham, this is the same Lamborghini that is listed in the intervener's pleadings, correct?
Correct.
And nowhere in any of these documents does it list you or Miss Lay, correct?
Correct.
Are you aware of the judgment against you agreed to against the interveners?
Yes.
What year did they pay you for the work on their residence?
I think it was 2009, sir.
Okay, and what did you do with the funds you earned in doing the work or attempted work on their residence?
Pay for mortgage and everyday expense and living and funds for kids' school, kids' education.
Is it your goal to use the assets awarded to you to pay off the interveners in full?
Objection, Your Honor. It assumes facts not in evidence. And additionally, we had previously objected before that it's not relevant, and I'm now saying that it's not relevant what he did with the money. It's not relevant to this case in the division of community, the community estate.
I believe the question was, what did you do with the funds you earned during the work or attempted work on their residence? Was that the question?
Yes, ma'am.
Okay.
It's not relevant, Judge, to the community vision. This was not a part of the record before. And I believe the Court of Appeal says that you just have to redivide the community estate, not for any judgments.
Counsel, what's the relevance?
So if they're taking the position that this debt should be put in the bottom line of the community, I'll move on. I just want to be sure, similar to what Mr. Davis argued, that this debt obligation is tacked on to the entire state, not taken off the top and put in Mr. Pham's column. And if it sounds like Ms. Allen is in agreement to that, so I'm happy to move on.
Okay, you may ask your next question.
Thank you.
I don't know what he's claiming I'm in agreement, but I just objected to the relevance. So I'm not agreeing with whatever he's saying.
Mr. Pham, are you asking the court to divide the property in a manner that will permit you to satisfy the debt owed to the interveners as a result of the judgment against you?
Objection, leading his witness.
Overruled.
Objection, he's leading and suggesting.
And I ruled. Overruled.
He's testifying.
Overruled.
I didn't hear you. That's all I said. I didn't hear you.
Okay, counsel, we've already established you didn't hear me. No more outbursts. Go ahead, counsel.
Pass witness.
Okay. Attorney Allen?
Yes. Now, let me ask you something, sir. Did you go with her to get that Lamborghini and did you pick it?
Objection, relevance.
Counsel, what's the relevance?
That he picked it and it's his. He bought it. That's what I'm trying to establish. He's trying to establish that it wasn't his. I'm trying to establish that it was his. So I'm asking it, did he pick it? And did he write the check for $200,000? That's just a yes or no.
Okay, so ask one question. Go ahead.
I didn't hear him answer.
You need to repeat
Can you
the
instruct him
question.
to answer, Your Honor?
I can instruct him to answer when you repeat the question.
Okay, maybe we're having a freeze because I can't hear you when you said that, Judge. On our exhibit number 12.2, sir. Can you pull it up, Erica? Did you write the check for $200,000 in buying this Lamborghini? Did you write that check, sir?
Objection, testifying to a document, not in evidence.
Sustain.
I'm asking my office. I don't have a checkup. I'm asking him to, Erica, can you pull up Respondents Exhibit 12.2?
And you all can share the screen when you need to.
Erica, 12.3 and 12.2. Quickly, please. Judge, is Erica on in my office? Okay. Sir, is this your writing?
May I answer, Your Honor?
Yes, you can answer that.
Not my handwriting, ma'am.
Judge, I'm just not clear. Is this being offered into evidence?
Nothing further.
Counsel, were you offering this into evidence?
No, he said he didn't, it wasn't here. I
Okay,
passed the witness. I don't want any more of my time.
okay. Attorney Davis?
Yes, Your Honor. Mr. Pham, I'm going to show you what has been marked as Plaintiff's Exhibit 15. Or sorry, Husband's Exhibit 15. This is your exhibit. Too many PDFs open. Can you see that?
Let me pull it up. Yes.
And it was your intention to present this as evidence to the court today?
Yes.
Your Honor, I would move to offer Husband's Exhibit 15 as evidence.
Okay, any objections?
No objection whatsoever.
No objection?
Okay,
I just one thing for the court reporter, and I apologize, this is my fault. With the exception of the first page, I messed up and did not cross out prior exhibit stamps. I'm sorry. It says defendants 4 through 6. Those are inaccurate. I apologize.
okay,
We're talking about right here, this
Yes, sir.
guy? Okay.
Attorney Emerson, would you please send your exhibits to the court reporter?
I will resend them. Yes, ma'am.
Okay. And Attorney Davis, does the court reporter have this? You have this?
Yes.
Yes, Your Honor, this is technically the husband's exhibit. It's not mine.
Oh, okay.
So,
Okay, husband's exhibit 15 is admitted.
Mr. Pham, can you see that this says the buyer is Trang Do right here?
Yes.
And the resident's phone number, the business phone number, that's your phone number, correct?
Correct.
And email quifam234@gmail.com. That's your email, correct?
Correct.
Your Honor, as a belt and suspenders, I'd move to offer Intervenors Exhibit A and Intervenors Exhibit B. They're certified copies of court pleadings.
No objection.
Attorney Allen?
No objection?
Okay. Intervenors exhibits A and B are admitted.
Looking back at husband's Exhibit 4 that you were just discussing, This, as you can see from the bottom title, has Trang Do listed as the owner of this property, correct? As the
Correct.
owner of the Lamborghini? Does she own more than one Lamborghini?
No.
And if we look down here, I'm not going to read the whole thing because the poor court reporter would hate me, but page 2 has a vehicle identification number. Oh, can't highlight it. Right here that starts either with a 2 or a Z, 2HWUR. Do you see that?
Yeah. Where you said at? Where is it at?
Right. Can you see my cursor by any chance? Right there.
Mhm.
Right there. Man, I'm terrible at this. Do I have a laser pointer in here somewhere? Do you see? It's ZHWUR12D6GLA04253. Do you see that on your screen?
Yes. Yes, I can.
So if Miss Doe only owns one Lamborghini, can we agree that this is the Lamborghini we're talking about? And that's the
Correct.
number for it?
Correct.
Pass the witness, Your Honor.
Attorney Emerson?
Can I get a time check?
Sure, I'll give everyone one. Attorney Emerson, you have 8 minutes and 19 seconds. Attorney Allen has 14 minutes and 37 seconds. Attorney Davis, you have 13 minutes and 7 seconds.
Thank you. Very briefly, Judge. Mr. Pham, as they pointed out, your name and phone, or your email address and phone number are on that purchase sheet for the Lamborghini, correct?
Correct.
Why?
I would just assist her in the purchasing.
Is English your Miss Doe's first language?
No, sir.
Would you characterize, how would you characterize her English skills, particularly in navigating the purchase of a $500,000 automobile?
Objection,
Very
relevant.
poor.
Hold on one second. I didn't get your objection, Attorney Allen.
Objection, relevance.
Okay,
Assumes facts not in evidence.
I'm going to further object, Your Honor, to speculation and hearsay. If they wanted Miss Doe to come testify about her ability to purchase this car, she could be here testifying.
May I respond?
yes, what's the relevance?
It's relevant because it seems as though they're trying to say his name and his email address and phone number being on there are problematic, and I'm eliciting an explanation for why. With regard to hearsay, there's no out-of-court statement we're trying to offer for the truth of the matter asserted.
Okay, overruled, I'll allow it.
Thank you.
May I respond, Judge?
No, I've ruled. You may continue, counsel.
And sir, I didn't hear your answer. You said her English skills with the ability to conduct a high-level transaction like this are what? How would you describe them?
Her English is very poor, sir.
Okay, pass witness.
Thank you. Attorney Allen,
Nothing further.
Attorney Davis.
No questions, Your Honor.
All right. Attorney Emerson, you can call your next witness.
I would like to call Ms. Trang Lei, respondent.
Her name is Lee, L-E.
Attorney Emerson, you may proceed.
Please state your full name for the court.
Trang Lee,
And do you own a Lamborghini?
no,
Have you ever purchased one?
no,
I'm not. I think I can hear it's just coming through a different person. Is that what's going on?
I can't hear anything.
Okay.
I can't hear
Did you?
anything that you're asking.
Hold on 1 second. Hold on 1 second. Attorney Allen, is your client in your office?
She's is we only have one mic on.
Okay, she needs to be in her own.
Can you hear her?
No, like maybe because you all are in the same space, we can't hear her at all. So is there a separate office that she can sit in?
Is it
Because-
mine that's freezing?
No, if she can't hear us, that means somebody is relaying the message to her. And that's not proper
Close.
to be able to
Is
hear.
she in front of me?
Attorney Allen's paralegal, would you disconnect her and restart her Zoom? Is Attorney Allen coming in on a cell phone? Attorney Allen's paralegal.
I'm sorry, I was helping her log back on. She's logging back on.
Okay, is she logged
Attorney Allen.
on Samsung or is it under her name?
It's on her cell phone, so I'm not sure what comes up.
Okay, thank you.
You're welcome.
Okay, can you hear me, Judge?
Yes, I can.
Okay, I'm sorry about that confusion. I couldn't hear anything and you was frozen. I'm not trying to be disrespectful, Judge. I'm just trying to hear.
No, I wasn't frozen. Your computer was messing up.
That's what I'm saying. You were frozen on my computer.
Oh, okay. Can your client hear? That's what's most important because she's on the witness stand.
She's in a different room, so you ought to be able to hear.
Okay. Ma'am, would you please unmute? I'm sending you a prompt.
Can you hear me?
Yes, I can. And Attorney Emerson, I paused your time during that.
Cool. Thank you. Thank you. Do I need to start all over?
The last question that I have here is, you asked her, has she ever purchased a Lamborghini? She said no.
And you aren't aware of any Lamborghini that Mr. Pham purchased during the marriage, correct?
I am aware.
Is that your allegations about that? Is that the one that we just entered exhibits on?
Yes,
Okay. And you were married to Mr. Pham at the time the judgment was entered into between Mr. Pham and the Casaleses?
yes.
Okay. And I'd like to show you, Judge, if I may screen share, what has been marked as husband's exhibit 12. Do you recognize that?
I can barely see it. Oh, is that an email?
Yes.
Yes,
And this is an email you sent Mr. Pham, correct?
yes.
Okay. And Judge, I would like to offer husband's exhibit 12.
Objection to relevance, Your Honor? Objection to settlement negotiations?
Okay. Attorney Davis, any objection?
No, Your Honor.
Okay. Counsel, is this a settlement negotiation?
No,
It's a
Judge.
settlement offering.
No, Judge.
That will be the last time. Hold on one second, Attorney Emerson. That is very unprofessional. That will be the last time that you make an outburst in this court. Go ahead, Attorney Emerson.
No, Judge. Way back when there was some payment schedules that pertain to child support and stuff like that they were sending back and forth, but they aren't attached, and what you'll notice what they're agreeing to is that the judge will decide. So I wouldn't call that a settlement negotiation.
Okay,
If you,
overruled.
may
Exhibit,
may I respond, Judge?
oh, you may not, I just ruled.
Well, you didn't let me give my objection.
You gave your objection, counsel. I asked him for a response.
I said it was settlement negotiation. I want you to read all three pieces because they talking about settlement back and forth.
If you make an objection, I can't read it. That's what the reason I asked counsel. Go ahead, Attorney Emerson. Husband's Exhibit 12 is admitted.
Miss Lay, this is your statement to Mr. Pham here that I've highlighted. Is that correct?
Yes.
Okay.
Objection, relevance.
She answered the question.
I'm trying to stop share, but it won't let me,
It
guys.
stopped.
I did? Okay, cool. I guess my screen is just stopping. Okay, so you guys can see all of us, it's not up?
Yes, correct.
Okay, sorry. Okay, and you sent this email immediately after the Court of Appeals decision was received, correct?
What is the date on it?
June 5th, 2023.
When was the appeal?
Ma'am, how much is presently in your checking account?
I don't know.
Okay. Is the Ferrari F430 in your possession presently?
No,
Did you sell it?
it doesn't belong to me. It belongs to my brother.
So when did you sell that to him?
He's always had possession of it.
Okay, when did it get titled in his name?
It's always been titled in his name.
Okay. And what is his name?
Ngauk Lee.
Okay. And is a 2017 Honda Accord in your possession?
Yes,
Okay. And your retirement account has about $160,000 in it, is that correct?
$158,547.
All right, pass witness.
Okay. Attorney Allen.
I'll pass the witness at this time.
All right, Attorney Davis.
Yes, Miss Lee. Are you sure you didn't transfer the Ferrari into your brother's name after this divorce case was filed?
No, sir.
Did your brother purchase the Ferrari?
I don't have the details how it was purchased. I wasn't a party.
But it was part of the original decree to be placed or divided to your community estate, correct?
Yes,
So you would have had to have given it to your brother, correct?
you have to ask Mr. Pham.
Did Mr. Pham buy the Ferrari?
I'm sorry?
Did Mr. Pham buy the Ferrari?
Well, they are in it together. I just know that it's in my brother's name and my brother has money in it.
You say your brother has money in it. What does that mean?
His investment with Mr. Pham.
Does your brother drive the Ferrari?
I don't know.
Did you have to sign any documents to transfer the Ferrari to your brother?
No,
But it was given to you as part of the divorce decree.
yes.
No further questions, Your Honor.
Okay. Anything further from this witness?
Subject to recall, no, ma'am.
Okay, thank you. Attorney Emerson, you may call your next witness.
Subject to recall, no further witnesses.
Okay. So you rest?
Yes, ma'am.
Attorney Allen?
Thank you, Your Honor. I first like for the court to look at my exhibits, respondents exhibit list and my exhibits. Ma'am, and I think that the court reporter has them. Can we verify that, Judge?
She has them.
Okay. So, Ms. Lee, can you tell us, ma'am, what you want this court to do today?
Award me my requested relief.
Okay. And what specifically is your requested relief? On the division of property, ma'am. Is that your exhibit number 5?
Yes, it is exhibit number 5.
Erica, can you bring that exhibit number 5 up, please? Now, the house that was awarded to you previously is the house at Mountain Lakes in Cedar Hill. Is that correct?
That is correct. Yes.
And on your exhibit number 6, you have the decaf value listed at $830. Is that correct?
Yes.
Okay. So on number 1, he put the value at 1.12. And what is the current value as of November of 2023 at the 2242 Mountain Lakes Drive?
830,000.
Objection, hearsay.
It's DCAD.
Judge, a person can testify as to what their opinion is, but I'm going to put it in an exhibit. If you can pull up exhibit number 6, please.
Okay, is she giving an opinion or is she giving what she saw of DCAD?
She's given an opinion, and now we're going to prove it. On number 6, exhibit number 6.
Okay, overrule.
Erica, can you pull up number 6, please? And did you get that from the decap, ma'am?
Yes.
For 2023 certified values.
Yes.
And it was told in this divorce action that Mr. Pham had bought his girlfriend and built her house. Is that correct?
Objection, leading. Objection, relevance.
What did he build for her?
Hold on, Attorney Allen. Sustain.
What did he build for her?
Objection, relevance.
What is the relevance?
Judge, because he said throughout the transcript that he wanted a divorce and that he built his house and he built the house and didn't charge her anything, nothing. A $1.4 million house.
Is the transcript an exhibit that the court should be looking at right now?
Yes, we have it on our exhibit list. So let me go ahead and ask the court to admit the transcript, Judge, which is our number 3. Can you pull it up, the transcript?
Okay.
If the court can take judicial notice and we can send you the transcript, but we all got the transcript, Judge.
The court cannot take judicial notice of the transcript, but if you wish to admit it as an exhibit, the court can entertain that.
I would like to admit number 3 as an exhibit, the transcript of the final trial.
Okay, any objection?
No, Judge.
No, Your Honor.
Okay, Respondent's exhibit 3 is admitted.
Can we go to exhibit 4.1, Erica? A portion of the transcript, ma'am, can you see respondents 4.1 on page 106?
Yes.
Line 8. Question. I want to read the question. I want you to read the answer.
Yes.
Okay. Now, with regards to the cars and vehicles that you bought up, did you state that you told your wife she could have those things? Is that correct? His answer.
Objection, Judge. She's testifying. The document speaks for itself.
No, Judge, I have the right to do what I want on my time. Is that correct?
No, you have the right to follow the rules. You can ask your client to read from the document and you can question her on it.
Ma'am, would you look at the document 4.1 on line 17? What is the question? What is the question, ma'am?
Okay, was it your intention to tell her that you did not have an interest in any of those things?
Answer. What did he say?
I'm not interested in any of those.
What is the next question?
Okay, so are you telling the court that all you want is a divorce?
Answer.
Yes, definitely.
Okay, let's turn to 4.2.
Yes,
4.2, page 309, line 18.
Your
The
Honor,
petition.
Your Honor, I just want a divorce final. I want to give her everything so she can sell what she needs to do so I can move on, Your Honor. That's why I release everything to her. I just want to move on with my life.
Thank you. Let's go back to exhibit number 5, please. Erica. So, ma'am, you are wanting the only car that you have, which is the Honda Accord. Is that correct?
Yes,
All right. And did you put that in your column then?
yes.
Now, let's talk real quickly about the GMC Sierra. And that is,
Objection, Judge. Relevance. That is the piece of property that the appeal was successful on, which is why we're here today. The court found that that was not part of the community estate.
the court found also, Judge, that the Lamborghini was a part of the estate. And so I want to show and correct the community estate on this GMC, where they said I was confused.
And
May I
Judge,
proceed?
characterization has already been decided. That's not it. It's well past plenary power for that.
Just the Lamborghini has already been decided, way past preliminary repair for that. So I'm looking to just show you where we got the 23,000 for it. And this isn't coming on my time.
Yeah, it's going on both of your times. So
I just need a ruling. Judge.
I gave a ruling. I said overrule, you may continue.
Okay, thank you. Let's go to exhibit number 8, testimony number 8, page 23 and 24.
Yes.
Okay, what did he say that he did with the truck, the F-350?
Objection, relevance.
What's the relevance?
Just as a part of the community estate. It's the truck he was driving then, when we did this divorce decree.
And may I respond?
Yes.
It is not in the final decree of divorce, and there's not a catch-all for automobiles.
Judge, it's in the final decree of divorce. It is in the final decree of divorce, and so is a Jeep.
Okay, counsel, did you want to pull up the decree and show me about the vehicle being mentioned in the final decree?
Absolutely. I don't know if it's, tell me if you guys.
No, not you, Attorney Emerson, Attorney Allen.
Sorry.
Oh, no, ma'am. No, ma'am, I do not.
Okay.
Let's go back to respondents number 5, please. Ma'am, where did you get the value of $102,000 for the F-150? F-350, I'm sorry.
Objection, relevance.
Counsel, are you just talking about characterization again?
Yes.
Okay, overrule.
Ms. Lee, did you hear me?
Please ask me the question again.
Where did you get the value of $102,000 for the 2022 F-350?
That was the Cali Blue Book at the time.
Objection, relevance, Judge. They were divorced in 2022. I mean, 2021.
Counsel, what's the relevance?
Ma'am, he bought a truck before they got divorced, and this is the truck he was driving. So even if they got divorced, it was September. He had already bought him a brand new 2022. That's why the GMC was traded in for the F-350.
It was purchased after the marriage, right?
During the
No.
marriage.
Judge, I don't believe he owns or ever owned a 2022 Ford F-350, but so
Judge, did you rule on it?
Overrule, you may continue.
Okay, so ma'am, let's talk about how then are you asking the court to look at the GMC's value? Explain to the court why you want her to give you the 23,287.
The GMC was part of the community property. He traded in the GMC, which he wasn't allowed to, for a new truck. And the trade-in value is the equity amount is $23,287.63.
And where do you get that number from?
Exhibit 7.
May you bring up exhibit 7, please? Erica, while you're doing that, can you bring up exhibit 7? Can you bring it up wider? Can you see that, Judge? Bring it up wider.
It's small.
And you see that number, it says equity amount, and what amount is that?
$23,287.63.
Judge, may I take this witness on voir dire?
Move to admit respondents number 7.
Objection. Objection, hearsay. May I take this witness on voir dire?
Yes.
Ma'am, it's your position that this truck was traded in for a 2022, correct?
This truck was traded in for an F-350.
A 2022 F-350 is what you testified to not a minute ago?
I'm testifying that it was traded in for a new truck, F-350.
And do you see the date on this? What is the date for the dealer's and buyer's signature?
September 17, 2020.
Are you asking this court to believe that the 2022 models were already out?
Your Honor, I want to object to this line of voir dire. This is cross-examination and not personal knowledge.
Overrule. Ma'am, you may answer the question.
Please ask the question again.
Are you asking the court to believe that a 2022 model was out in September of 2020?
I'm testifying that the GMC truck was property and it was traded in for an F-350.
Objection, non-responsive.
Hold on, one question. This is the question, ma'am. Do you want the court to believe that a 2022 model was out in September of 2020? Yes or no?
I don't know.
May I qualify? Is that the right number? Was it a 2022 or was it a different model?
I know that it's a Ford F-350.
Okay. But that's where you got the number amount. Is that correct? Now let's move forward.
Objection, hearsay, if she's getting it off this sheet.
Judge, I move to admit respond to 7. It's a 2018, Judge. I'm sorry.
Well, that conflicts with her testimony.
No, she never said that. Well, I'll move on, Judge.
Okay.
Judge, I do want to admit respondents number 7.
Objection, hearsay.
Sustain.
Do you recognize your husband's signature on the bottom of this as buyer's signature?
Yes.
Is that his signature?
Yes.
How do you recognize it?
I've seen it.
How many times?
Many times.
Move to admit number 7.
Objection, hearsay.
Sustain.
Okay. Ma'am, let's go to your exhibit number 10. What is it?
Title application for a Mastercraft.
And is that the boat that you were awarded?
Yes.
Whose name is on the boat?
Long Nguyen.
And who is that?
His business
Yes.
partner.
Objection, relevance.
Counsel, what's the relevance?
This is a part of the, all this is a part of the community estate at the time of the divorce. This boat was awarded to her. It's titled to somebody else. It does not belong to her. She does not get the boat because it belongs to Long Wind.
Overrule, I'll allow it. Ma'am, you may answer the question.
It belongs to Long Wind.
Now, what was the what did your husband used to do when he bought vehicles and things of that sort? What would he do?
Objection, relevance.
Well, we're trying to explain these titles. I think it would help the judge. When he want to buy a vehicle, what would he do? Would he put it in his name?
Objection, leading. Objection, relevance.
Counsel, what's the relevant? Well, sustain as to leading, but what's the relevance?
Judge, you'll find that these titles are titled to other people. So the relevance is what his mantra was. What he always did was bought things and then put it in other person's name. I'm going to ask I want to ask my client, how many times did he do that and on what items? This would help the court to know what's community property and what's not.
And Judge, she just hit the nail on the head. We aren't here determining what is community property and what is not. The plenary power is long since passed for any of that. We are not.
Okay.
Continue, Attorney Emerson.
We are not characterizing. All that we're doing is valuing and asking you to divide it as you see fit, just and right. And as far as I could tell, this has nothing to do with valuations.
Sustain as to relevance.
Then
Attorney,
we just
you have 2 minutes and 2 seconds. Attorney Emerson, you have 2 minutes. Intervener has 11 minutes and 5 seconds.
Ma'am, how much you have in your retirement?
$158,547.
And how much does he have in his?
$161,916.
Did you put in his column what you think that would be a fair and just amount for both you and he?
Yes.
Okay. Now you have life insurance that he claims is $25,000. How much do you have in life insurance? The cash value, ma'am.
Objection, leading. Objection, sidebar.
Overrule, you may answer the question. How much do you have in life insurance cash value?
$4,817.80.
Ma'am, you prepared this proposed property division, is that correct?
Yes.
And is it true and fair representation of the exhibits and all the things that you have talked about and want to talk about, ma'am?
Yes.
Is this a summary of your property division? We move to admit respondents number 5, Judge, with this.
Any objection?
Absolutely. Absolutely, Judge. It includes a multitude. In fact, the majority of it is
What's the
items.
objection?
Objection, relevance. Objection, facts not in evidence. Objection that it goes well beyond the scope of the appellate court's mandate. There is property in here which is not found within the final decree, which there has been no testimony elicited, valuation, which there has been no testimony elicited, and which is not contained within the decree.
Sustain.
Judge, everything on here is contained in the decree. That's why you have the exhibits on the side.
What the court is going to do is
Move to admit, Judge.
the
May I
court,
move to
I've already, Attorney Allen, if you would just be quiet for 1 second, you would hear my rulings. I'm not going to talk over you. The court will consider the portions that the Court of Appeals has mandated that the court considered. Everything else is not going to be relevant to the court's ruling. So you can admit it, the court will admit it, but the court is only entertaining those portions that was mandated.
Understood. Understood. Now, what about, ma'am, what about the debts of the marriage? On page 2 of respondents number 5, what do you want to make sure that he pays for, ma'am?
For all the credit, the City Visa, TJ Maxx, Wells Fargo Visa, Discover, funeral expense reimbursement, all the attorney fees.
Okay, and the prior attorney fees was how much?
Objection, Judge.
$31,000.
Make your objection.
Objection, Judge. Relevance. May I take the witness on voir dire?
Yes, you may.
Ma'am, you've got valuation for these debts on here. Is that correct?
Yes,
You provided no documents as of the 30-day deadline for this trial about these debts, did you?
there's no 30-day deadline.
Okay.
There
So
was no mediation.
so the pretrial order had a 30-day deadline to exchange documents. You provided no documents about these, correct?
No,
Okay, and these expenses had already been paid by you. You're
No.
asking that they be repaid, correct?
I had to pay it so I wouldn't go into bad debt.
So these balances are zero as of today, correct?
Yes,
Okay, pass witness. I'll renew objection to relevance.
Sustain. And the document is excluded.
I thought you just already,
Any document that was not timely produced pursuant to the court's trial order is excluded.
well, Judge, she did give him the divorce decree. The divorce decree was given and all of these amounts are in the divorce decree.
Counsel, you may ask your next question. You have 20 seconds left.
Are you asking them to, you're asking this court to make sure that your attorney's fees are paid both to you and me that was previously ordered by this court?
yes,
And let's talk about the newly found evidence, the McLaren. Now, the McLaren was part of the decree at the same time. We talked about,
Objection, relevance, and leading.
Sustain. And Attorney Allen, you just ran out of time.
Okay. may
Attorney,
I ask for more time, Judge? There's no way possible that I can do a whole day trial in 20 minutes with all the objections and all the technical problems.
counsel, you are more than welcome to ask, and the court is going to deny that request. Attorney Davis, you
Judge, may I get it in? Judge, may I get in the title so you can verify who owns?
I'm just gonna mute you. I'm not gonna talk over you. Attorney Davis, any questions?
No, Your Honor.
Okay, Attorney Emerson, you have 40 seconds left. If you choose to give a closing, and Attorney Davis, you have plenty of time if you choose to give a closing.
Yes, just very briefly, Judge, we just ask that, sorry, is it time to
Yeah,
close?
go ahead.
Thank you. We just ask that it be divided pursuant to the requested relief we've submitted. We're okay with either using Ms. Lay's numbers or Mr. Pham's numbers. Either way, the goal is to sell the house, and I understand those are exempt assets, but our goal is to satisfy the intervener in full. We also ask that the strict language of the decree regarding both the community estate and the Lamborghini as either the Lamborghini or not a component of the community estate based on its position in the decree be followed strictly, as that was the rule of the Court of Appeals. Thank you for your time today. I know you kind of squeezed us in. We really appreciate it.
You're welcome, and you just ran out of time. Attorney Davis?
Yes, Your Honor. I promise I will not use all 11 minutes. I agree with Mr. Emerson that the Court of Appeals mandate is limited to division. I disagree with him, obviously, regarding the treatment of what the Court of Appeals and what the decree says about the Lamborghini and what you found in your first run at this case. I believe the decree does say that the Lamborghini was purchased with community assets, which makes it a part of the community estate. What the Court of Appeals mandate did not contemplate was that a judgment creditor would intervene because that had not happened yet. We had not been instructed by the various courts and we didn't know about this divorce proceeding. I didn't get the underlying judgment. It came to me later. However, it is clear based on the family code, the judgment that was issued with findings of torts, that the non-exempt assets in the community estate are subject to execution to satisfy the judgment. And that's both Mr. Pham and Ms. Lee's, however the community estate was divided. For the intervener's part, I believe that includes the Lamborghini. The purpose of my examination today was to give you the VIN number of the Lamborghini. It is now in the record. The Lamborghini can be clearly identified. Mr. Pham testified that Miss Doe has only ever owned one Lamborghini and she owns one Lamborghini. So the question of which Lamborghini or what Lamborghini is resolved for the court today. If you look at page 52, section 3 of the original decree for the portions that have been affirmed, very curious about the McLaren, but that's not before the court today. The Ferrari is identified by VIN number. Each one of these individuals is entitled to $50,000 in exempt assets, and vehicles are included in that calculation under section 42 of the property code. You're also entitled to one vehicle. The Ferrari is worth more than $50,000, everyone agrees. So that cannot be the exempt vehicle. The Ferrari should be turned over to the interveners. The Lamborghini should be turned over to the interveners. The Mastercraft boat, which is in section 52, page 52, section 3, should be turned over to the interveners. These are non-exempt assets. You do not get an exempt boat. I don't care how much it's worth. The timeshare on page 42, W-3, should be turned over to be liquidated to the interveners. These are all non-exempt assets. The jet skis identified in H5 on page 40 of the decree should be turned over for liquidation. I believe Mr. Pham has designated the Lexus as his exempt asset or his exempt vehicle. I can't touch that. I can't touch retirement accounts. I'm not asking for that. Those are exempt. But these toys, these extra vehicles, I appreciate Mr. Emerson's position that Mr. Pham is going to satisfy the debt. In the year and a half that I've had this case, nothing could be further from the documentation. There's nothing to show Mr. Pham has any desire to satisfy this judgment. It's possible the only way that the Casaleses, who are in their 70s and still working because they lost everything, are going to get any satisfaction is through you and through the turnover of these vehicles. We have a motion for turnover on file. There's not a final judgment yet, but there is a vehicle before the court in which to do this via the turnover statute. We have a final judgment. Rule 31, I think, can apply. I don't really want to give these items to a constable because constables sell things and the return is 20 or 30%, and these are valuable assets. And I think it's in everyone's best interest that we maximize the value of these items. We can put it with a broker who sells exotic vehicles to maximize the recovery. I don't want to sell a Lamborghini for $50,000. That's not the goal here. It's not just to take stuff. The goal here is to maximize the recovery. I don't know, but however, I need everybody's agreement to do that. Otherwise, I've got to use the constable. But these assets, the non-exempt assets that I've identified, are likely the only way that Casaleses see any recovery at all. And so I'm going to ask that all of these non-exempt assets that I identified be, as part of the decree, delivered to the interveners. Thank you, Judge.
Thank you. Attorney Emerson, I got your message about the exhibits being sent. So the exhibits that the court has, petitioner, that the ones that were admitted, offered and admitted, petitioner's exhibit or a husband's exhibit, 1, 20, 18, 19, 23, 14, and 12.
I got 15 also, A and B.
50.
Well.
Yeah, they intervener offered it. I separated them as who offered it. Intervener offered husbands 15 and A and B. Is that correct?
Yes, Your Honor.
Okay, and for respondent, I have exhibit 3.
And Miss
And exhibit 5.
Exhibit 5 wasn't offered.
I offered it and you admitted it, Judge.
No, you offered it and you moved on. Exhibit 5 was not admitted. And exhibit 7 was sustained. The only exhibit was 3.
And that's the one I
And that's the one we need.
So what did you say? I admitted it and you said what? On number 5?
No, you admitted it and you moved on. You
I didn't ask for admission.
correct. You started to do it, but then y'all started, you and Mr. Emerson, you started talking over him and then you moved on.
Judge, you said it'd be admitted, but the items in the debts would be excluded.
Okay, respondents exhibit 3 is what we have, and that's what we need. If you'd be so kindly to send that to my court reporter.
Okay, she doesn't have it. Well, let's see, what was number 3? So Judge, may I respond to the intervener?
No, no, testimony is closed.
Steve has it, he's got it labeled as 4. Just FYI, it's labeled.
Okay, you have it labeled as 4.
Okay.
Joey is sending me that, and then we can get started. All right, Joey, let me know when you're ready. All right, we're on the record in cause number DF 1906267. Counsel, will you please announce for the record?
Yes, Margaret Hardage, attorney for Bianca Bravo, petitioner.
Keith Salazar, attorney for David Bravo.
All right. With
And
those,
Alina,
I'm
sorry. Alina Franklin is here with the Office of Attorney General. We filed an intervention.
Okay. And then we have Ms. Ortiz from Family Court Services, right?
Yes, Your Honor.
Okay. All right. With all those who intend to testify, please raise your right hands. Do you all swear or affirm that the testimony you're about to present will be the truth and the whole truth?
Yes, Your Honor.
All right. We are set here today on a final for a modification. Prior to going on the record, you all had an exhibit conference and you stipulated to some exhibits. So at this time, petitioner's exhibit, which is mother's exhibit 1 is admitted as a summary. Respondent's exhibit 4 is going to be admitted as a summary. And respondent's exhibit number 1 is going to be admitted as well. That's the custody evaluation. It wasn't submitted to the court because the file was too large, but the court is taking judicial notice of all contents of the court records and will admit the custody evaluation as an exhibit. All right. Is there anything preliminary that the court needs to take up prior to getting started?
Just my other witness that's here is the current wife, my client. So she's accepted from the rule in case of being excused.
Okay. Counsel, are you invoking the rule?
Yes, Your Honor.
All right. So let me get her to state her name. Ma'am, would you please state your name?
Yes, ma'am. Mashika Bravo.
Okay, thank you, Ms. Bravo. So at this time, the rule has been invoked, meaning that you would have to remain outside of the courtrooms if you were physically here. So you would have to remove yourself from the room that you're currently in and go to another room. You're not allowed to watch this live stream on YouTube or have any conversation with anybody related to the case. And once you are called to give testimony, then Attorney Salazar will make sure that you get into the room. Well, I'm assuming because of the way that you all are set up, your husband will let you know when it's your turn.
Yes, ma'am.
Thank you so much.
Judge, am I incorrect to understand that the rules allow a spouse of a party to be in the room during a case if they are married? That's an exception to the rule.
I don't know. And I don't know. I do not know. I normally just
I think that's been the rule since I've been practicing 36 years, but maybe
I don't know if it's a rule or if I don't know if that's an actual rule or judges just allow it. But even when we're present in the courtroom, when the rule is invoked, everybody just stands outside. And I've never had anybody object.
I'll solve it this way, Judge. I would object to my client's wife not being present in the room. However, if the court overrules my objection and asks her to step out, then that's fine.
Do it like, how are you going to call your witnesses?
First, actually, I was going to call Miss Ortiz. And
you're going to call her?
Yes.
Oh, well, if you're going to call her, then she can stay there.
No. Well, Miss Ortiz is the family.
Oh, I'm sorry. Yeah. Bravo. Excuse me. Yeah. Bravo is your client's last name. Okay. Right. Yeah, I don't know. And nobody has ever objected to that. I mean, counsel, do you have any objection?
I don't have any objections, but.
Okay. Yeah, then she can stay.
Okay. Thank you, Judge.
Yeah, good question. I have to go do some research on that one because I'm not sure. And I do not mind saying I do not know.
Okay.
Okay. All right. So the issues that I see before the court are conservatorship as well as possession and access. And you all have come to an agreement about the amount of child support. Is that correct?
We are asking for arrears. And for our medical support, my client's insurance has gone up a little bit. So we were requesting an adjustment for that. But.
Okay. All right. So I will get information from the state on that one. Matter of fact, now that I'm on that point, does anybody, well, never mind. Go ahead, Attorney Salazar.
I was just going to say that my client was not aware of any kind of arrearage, and that he states that he's been current. But that's something we can address individually with the Attorney General, either during the trial, or we can just agree on the Attorney General's numbers and they review it.
And so, Judge, we included them in the intervention we filed, but I do have updated numbers for the arrears for the judgment amounts.
Okay. All right.
I think my client is she might be having computer issues. Bianca, can you?
She's on mute.
Excuse me, Your Honor, my computer keeps freezing, so I keep going in and out. And do I have permission to log out and log back in? I don't know how to fix it.
Yes, ma'am, you do.
Thank you so much.
You're welcome. We'll go off the record until she comes back. It might be easier. It might be easier for me to remove her and then she try to log back on.
Okay, yeah, maybe do that.
Let me try that. Okay, now see if, ask her to see if she can log back on.
Okay.
Was she able to get back on? I haven't received a notification yet.
Yeah, my paralegal just said they're having tech difficulties. Let me follow up. Would you mind, I guess, if she just comes and testifies next to me on my own computer?
No, that's fine. It's probably cold in here.
Yeah. Okay. Okay, so sorry about that. We should be back.
No problem.
Okay.
All right. All sides ready?
Yes, Your Honor.
Okay, so
Sorry, Your Honor.
you all can choose to give an opening statement or a closing statement should you, I mean, it's your choice to make one. You don't necessarily have to, and that will include any examination for your time. You all are set at an hour total, so that's 20 minutes per side. Since there is the third party intervention from the state. Is it Hardage?
Yes, it's Hardage.
Okay, Attorney Hardage, would you like to give an opening statement at this time?
Yes, please. I'd like to give a brief opening.
Okay, go ahead.
Your Honor, this case is about the children's best interest and stability. Bianca Bravo has always been the children's primary caregiver. She gets them to school, coordinates their medical and mental health care, and actively advocates for their education, securing one daughter's placement in a pre-collegiate program and the other's enrollment in a STEM program. When her daughter struggled with anxiety, Bianca sought help. When her living situation became unhealthy, she moved out, stabilized her home, and relocated the children to a better school district, all while working multiple jobs. Every decision she made put the children first. David's conduct shows a very different pattern. He has resisted mental health care, refused tutoring during his possession, and prevented school activities when they conflicted with his schedule. Where Bianca adapts her life to meet her children's needs, David expects the children to adapt to him. The litigation history matters. Bianca filed this case to secure mental health care for her children. David responded by seeking primary custody. When temporary orders limited his control, he pursued a de novo hearing. When that failed, he filed a motion to modify the temporary orders, which was also denied. This escalation is not about the children, it's about control. There's no evidence these children are unsafe with their mother. The evidence shows stability, progress, and advocacy, and disrupting that would not serve their best interests. For these reasons, we ask the court to deny respondents' requested relief and to enter orders that preserve stability and protect these children.
Thank you, counsel. Attorney Salazar?
I'm gonna hold for closing, Judge.
Okay. Attorney Franklin?
Same judge. I'll hold for close.
Okay, all right. Attorney Hardage, you may call your first witness.
I'd like to call my client as my first witness.
All right, you may proceed.
Can you please state your full name for the record?
Bianca C. Bravo.
And are you the mother of the children subject of this suit?
Yes.
How many children do you share with David Bravo, the respondent?
2.
What are their names and ages?
Jasleen Bravo, she's 13, and Zarina Bravo, she's 10.
And did you initiate this modification suit?
Yes.
And why did you feel it was necessary to ask the court to intervene at that time?
Because my daughter's anxiety was escalating to the point that it was affecting and impeding her learning and physical health.
And what symptoms or behaviors were you observing relating to your daughter's anxiety?
Impeding her learning, difficulty.
Attorney Hardage, hold on 1 second. You have to slow down.
Okay, sorry, trying to get my time. Yeah.
Yeah, Joey is reading. I mean, she's writing everything you're saying. So just slow down a little bit.
So what symptoms or behaviors were you observing relating to your daughter's anxiety?
Impeding her learning, difficulty concentrating in school, emotional deregulation, daily concerns from teachers, and daily visits to the nurse.
And did you inform Mr. Bravo about these concerns?
Yes.
And how did he respond when you raised them?
He immediately denied it and suggested that I was lying.
And did he support recommended counseling or treatment?
No.
And what position did he take instead?
Again, he immediately denied her having any anxiety and that he felt that I should give him full custody and pay him child support.
And did you request a temporary orders hearing so that you could obtain treatment for your daughter's anxiety?
Yes.
And what did the court order at that hearing regarding your exclusive rights?
That I have exclusive medical and psychological rights for my children.
And since receiving that authority, what steps have you been able to take to support your daughter's mental health?
I reached out to Genesis. Both my children have individual and family counseling. I was able to get my second daughter that was diagnosed with anxiety disorder, her formal diagnosis. Then I took that diagnosis to the educational diagnostician with the school district, Then we were able to get her an IEP formally to where now she has school psychology every 6 weeks per grading period, per the IEP, per the IDEA.
And have you observed changes in your daughter since receiving consistent mental health support?
Significant positive improvements, yes.
And are you asking the court to continue granting you exclusive decision-making authority over your children's medical and psychological care consistent with the current temporary orders?
Yes.
And are you also asking for exclusive decision-making power over the children's educational decisions?
Yes.
Why are you asking for this?
Well, as an educator and a mother, I have consistently prioritized my children's educational needs and their development, enrichment opportunities, and here surrounded their school environment. David has denied all advanced tutoring opportunities and has no interest in their academic planning or educational future.
And where are your children currently enrolled in school?
Irving ISD, Brown Elementary, and Lamar Middle School.
And how are they doing academically and emotionally there?
They're doing really well academically and emotionally. I'm proud to say that I have gotten my children into the collegiate program with the dual pathways for high school and the STEM Academy for middle school.
And does either child have any special educational needs?
Yes.
What are they?
After the determination in an R committee decision, we thought that she would have an OHI, which is other health impairment, but they determined that she had emotional disturbance based on her anxiety disorder.
And how have you advocated for those needs?
I've coordinated the counseling, the evaluation, attended meetings, and communicated regularly with the educators, ensured the implementation of her IEP with accommodations, and I remain in contact with her case manager at the school.
And can you describe Jeslene's academic program or track?
Yeah, I'm proud to say that I got my daughter Jesline into the collegiate academic program with dual pathways for Irving ISD.
And what opportunities does that program provide for her?
It allows her to graduate with her high school diploma, her associate's degree, and a trade.
And if your daughter were to primarily live with her father, as Mr. Bravo is requesting, would she still be able to attend this collegiate program?
Unfortunately, no. The program is located pending, and she would lose all future opportunities to be in that program.
And how would changing primary custody impact the children's schooling mid-year?
It would impact them significantly for their academics, emotional security, social disruption, mental health supports, their daily structure, consistency.
And can you describe any involvement Mr. Bravo's wife has had with your children's school?
Yes. She contacted my children's teachers.
And how did you learn about this?
They emailed me snapshots of the messages.
Objection here, say Judge.
Sustain.
Okay. And are you also requesting for exclusive authority to apply for and maintain passports for your children?
Yes.
And have you experienced difficulties obtaining passports for them in the past?
Yes.
What reasons has David given for opposing the children having passports?
He stated that I would leave the country with my children.
And are you also asking that David continue to exercise possession under the expanded standard possession schedule?
Yes.
That said, are you asking that he return the children at 6 p.m. on Sunday like you're currently doing?
Yes.
And how does this return time benefit your children?
It allows adequate time to transition, to complete evening routines, reset, prepare for school week, finish and complete the school assignments they have not been completed, and get appropriate rest, overall consistency and stability.
And typically when the girls come back, have they not completed their homework?
No.
And since you and David separated, who of the children primarily lived with?
Me.
And when did that arrangement begin?
Majority of their lives.
And has that arrangement ever changed?
No.
And who currently lives in the home with you and the children?
Nobody.
Do you have a daughter of another marriage?
Yes.
Does she live in the home with them?
Yes.
And how long have your daughters and their half-sister lived together?
Since she's been born.
And how would you describe their relationship?
Very close, loving, and playful, just a great sibling bond.
And if primary custody were to change, like Mr. Bravo is requesting, how often would your daughter see their sister?
Never,
Why would they never see her?
because of the possession schedule, it would be opposite, so they would never get an opportunity to see each other.
And how would separating them affect your daughters emotionally?
It would impact them greatly. They distressing, destabilizing, traumatizing, just total disruption of their family dynamic.
And can you describe your ability to communicate with your children while they are in their father's care?
Difficult.
And what typically happens when you attempt to speak with them during these times?
I request to speak to my children with David, and he denies me access to them.
And at the time of the child custody evaluation, where were you living?
I was living with my mother.
And would you describe that environment as healthy or stable?
No.
And why did you initially move in with your mother?
It was due to COVID and during the pandemic, and she lost her job. So we came in and we supported each other.
And have your circumstances changed since then?
Yes.
Where do you live now?
I live in Irving with my girls.
And how long have you lived there?
For 9 months.
And are you living in your own apartment?
Yes.
And is this intended to be your long-term residence?
Yes.
And what differences have you observed in your children since you moved?
They're noticeably more relaxed, emotionally grounded, balanced. They just appear happier, more laughter, and a greater willingness to share their thoughts and feelings.
And during this litigation, Mr. Bravo was ordered by the court to take a drug test. Is that correct?
Yes.
And what were the results of that test?
He tested positive.
And have you been reimbursed for the cost of that drug test?
No.
And how much did you pay for that test?
$310.
And are you asking that he reimburse you for the cost of that drug test?
Yes.
And are you also asking the court to grant everything that's requested in your requested relief?
Yes.
And do you believe that all of your requests are in the children's best interest?
Yes.
I'll pass the witness.
All right.
Thank
Attorney
you.
Salazar.
Thank you, Judge. Isn't it true that actually your children have reported that they've been mentally and emotionally abused by you, causing them anxiety and confusion?
I'm going to object as to argumentative.
I believe that's what's in the custody evaluation.
Right.
Overrule.
No.
Okay. So you don't believe if they said that's true?
No.
Okay. But is it true that you have spoken negatively and in inappropriate ways regarding their father and their stepmother?
No, never.
Okay. So even though the children reported it, you're saying that they'd be lying at that time?
I'm saying that I did not say any yucky things or ugly things about them.
Have you ever used physical discipline to the children that's been brought to the attention of the counselors and CPS?
No.
So CPS was never notified by the counselors to come and speak to you regarding physical discipline of the children?
Not my 2 children, no.
Okay, so you're saying right now CPS you never talked to CPS about your children?
About my 2 children, no.
So if that were in the report, you're saying that CPS contact is a lie, is not true?
The CPS is closed. The case is closed.
Okay, but so CPS did investigate, is that right?
No.
Now, isn't it true that when the children come back from visiting their father and their stepmother, that you do interrogate them and wanting to know what happened and what's going on over there?
No, never.
Isn't it true that when the children did an interview in preparation for the social study, that afterward you interrogated them and wanting to know what was discussed and what they said?
No.
So if the children were to have reported that, are you saying that the children were lying?
I'm saying that I never had that conversation with my children.
Okay. So if it was reported, you're saying that's not true?
I'm saying I did not have that conversation with my children.
Okay. isn't it true that Zarina's afraid of you because you become angry and physical?
No,
Isn't it true that you yell at the children?
no,
Isn't it true that you get angry or become hostile to them if they start to talk about their father and how much they love their father and their stepmother?
no,
Now, you said that you're the one that went to get mental health care, but isn't it true that it took a while for you to go out and get them help?
no,
Now, isn't it true that part of this health care is due to the fact that your daughter, your oldest daughter, Jasleen, started to cut herself?
I was already in the process of getting her counseling prior to that anyway. She
Okay.
already had counseling services.
Okay, but your daughter does have a history for a bit of time of acting out by cutting herself in her arm. Is that right?
She does not.
So you're saying she never cut herself?
She had one incident and David was contacted. The crisis line was contacted. Her current counselor was contacted. The school counselors were contacted. Everybody was contacted in order to help her that very day, and it has never happened since.
Okay. And in the past, isn't it true that you've had a pattern of withholding the children from visiting with their father?
No,
And are the children currently in therapy?
yes,
Okay. And who are they in therapy with?
they have therapy with Genesis.
Okay. Do you know the therapist's names?
I have. What am I supposed to divulge
You can
information?
state the therapist names.
Okay, we have Chandler, and then we also have Navia.
Okay. And isn't it true that the father also is responsible for taking and dropping off and picking up the children whenever they have therapy when they're in his possession?
No,
So you're saying the father doesn't take them to therapy?
no,
Have you ever had any kind of mental health diagnosis yourself?
no.
Have you ever been to a therapist yourself?
Yes, I have for domestic violence.
Okay. How about mental health?
That is a part of my process.
Okay. And have you ever been diagnosed with any kind of issues such as depression or anything like that?
No, just helping me with my domestic violence caused by being a victim in this marriage.
Okay. Now, you mentioned a drug test that you want to get paid for. That was from 2 years ago, 2023. Is that right?
3 years ago.
2023? Yeah. Okay. And that's the only one you had to pay for, right? Or that you paid that you want to get paid for, right?
Reimbursed based on what the court had deemed him to do so.
All right. And there have been other drug tests which you've did, which but the other drug tests come back negative. Is that right? That you're aware of, or you're not aware of?
There were no other drug tests.
Okay. All right. Now, in your requested relief, you're saying that you want the stepmother to play no role in these children's lives as far as, going to school or picking them up and dropping them off. Is that right?
I'm going to object as to a misstatement of the facts,
It's the requested relief, Judge.
but that's not what's in there.
Okay, sustain, rephrase.
I'll rephrase. So isn't it true that you're asking the court to order that only you and your husband communicate regarding parenting matters regarding the children?
I don't have a husband,
I'm
but
sorry,
I would,
the father, the father.
but I would like for David and I to remain the co-parents and the ones making decisions together, yes.
Okay, but you're also, in that same request, you're asking that step parents or third parties not contact the children's schools, medical providers, therapists, or any other extracurricular providers on behalf of the other parent. Is that right?
They don't have any educational or parental authority to do so. So if I can't contact the school, then I should be able to reach out to David and vice versa. We have to be able to co-parent.
Well, don't you think that puts the kids in a bind if, like, for example, they have a practice gets out early and they need to contact somebody and to contact the dad and he's working, that the stepmom could be able to go pick up the children. Wouldn't that make sense?
But wouldn't it make sense for me to do so? I'm the parent just as much as he is.
So like I said, are you objecting to the stepmom having any involvement with the children? Or regarding aspects of children with school, extracurricular activities?
I'm objecting to her not having educational authority and or rights.
Okay. Now, also you're asking the court to order that the children not call their stepmom mom. Is that right?
That's right.
So you want the judge to order these children who may want to call their stepmom mom, that they can't do that. Is that what you're asking?
They have a mom.
I'll pass witness, Judge.
All right, Attorney Franklin.
Yes, Judge. It'll be brief. Ma'am, you understand in your requested relief, you made a request for a judgment on the arrears that are currently owed on the case?
Yes, ma'am.
Okay. And do you understand, or are you aware the previous order did require payments for current child support as well as current medical and a prior order for dental?
Yes, ma'am.
Okay. And so do you understand, because of that, the Office of Attorney General would also be requesting a judgment on arrears for the child support, medical support, and dental support?
Yes.
All right. Are you in agreement with the state requesting judgments for those amounts? Basically, it will be 3 separate judgments for child support of $666.26 as of December 31st, 2025. Are you in agreement with that, with a judgment for just the child support arrears?
And then medical support on top of that.
And then medical support on top of that, yes.
Okay, and the medical support judgment would be $556.58.
Okay, thank you.
And then there's also a dental judgment of $95.17. Are you in agreement with that?
Yes.
Okay. And then just for clarification, as far as the health insurance, and I know you all agree to that, is it private health insurance through your employer?
Yes.
Okay. I'll pass the witness, Judge.
Right.
I have some additional questions for my client.
Go ahead.
Just to clarify, there was a CPS case that was open during a child custody evaluation, is that correct?
Yes.
But it didn't pertain to the children subject of this suit, is that right?
That's right.
And it was ruled out, is that correct?
Correct.
Also, do you ever tell your children to advocate for themselves?
Always.
And do you think that this could be misconstrued as telling them what to say?
Yes, I try to advocate for them whenever they would return back from their dad saying that he made them cry, yell, would put his wife in front of them before their feelings, hurt them emotionally and mentally. So I would try to advocate this was their opportunity to have a voice whenever they did get to speak to the evaluator, that this is your time to say, like, these are all the things that are going on. I just want you to feel like
feel and know that you have a voice and somebody is willing to hear you.
No further questions, Your Honor.
All right. Okay, counsel, you may call your next witness.
I was going to just one more question to the mom.
Okay, go ahead.
So you did discuss with them about participating in the investigation regarding family court services, is that right?
Not participating, no, just letting them know we had a meeting to meet with them.
Okay, all right, thank you. No other questions, Judge?
All right, counsel, you may call your next witness.
I will call Mr. Bravo.
All right.
Mr. Bravo, what change are you asking the court to make regarding custody?
I'm asking to be the primary caregiver.
And please describe your current job and your typical work hours.
Typical work hours are Monday through Friday, generally 8 to 5 p.m. And I deliver packages for FedEx.
And on a regular school day, who would be responsible for taking the children to school?
It could vary, but more than likely it'd be my wife.
And who would be responsible for picking them up?
Her as well.
And what role does your wife play in helping the children's daily needs?
Daily needs, really everything. She feeds them, clothes them. She'll pick them up from school, like we talked about, pick them up, drop them off. She has a lot of benefits with her job, so through that they've been in counseling. But it's a general overall good relationship.
And are you aware that your wife contacted the school regarding your daughter's participation in the security program?
Can you repeat that question again?
Are you aware that your wife contacted the school regarding your daughter's participation in the security program?
The only thing I'm aware of is when she went to pick them up and my daughter wasn't ready in the pickup line. That was the only contact that I was aware of.
Okay, and what did your wife tell the school about your daughter continuing in that program?
Objection here, say Judge.
Sustain.
And have you ever told mother that the girls can't attend their weekend tutoring when they're in your care?
No, I'm not even aware that they were enrolled in tutoring.
Okay. And when the children are with you, how are they able to communicate with their mother?
Through my cell phone, through App Close, the app that we use.
And are there times when the communication doesn't occur?
Rarely, yeah. There's times.
And you were required to submit to a nail sample drug test, is that correct?
Yes.
And what was the result of that test?
A positive for marijuana.
And have you completed any substance use treatment or assessment programs since then?
No.
Okay. No further questions.
All right, Attorney Salazar.
Mr. Bravo, what concerns do you have with the children continuing to live with their mother?
The main concern is their mental health and well-being.
When you say that, what specifically, what kind of behavior have you noticed from them that makes you concerned for that?
Extreme anxiety, which led to my oldest daughter cutting herself and also pulling out her hair. I forget the term for what that's called, but their overall anxiety is.
Okay. When this first started, did the mother bring this to your attention in any way?
No.
How did you discover that your child was having issue? Which child is it first to begin with? Which child was having these issues regarding the cutting and the hair?
Our oldest, Jasleen.
Okay. How old is she right now?
13.
Okay. And how old was she when she first started?
She would have been 11.
Yeah. And how did this come to your attention that she was having these issues?
When we would pick her up from my possession weekends, they were always pretty anxious to come over. But as far as seeing the cuts, over the course of the summer, we were swimming and I saw a lot of scars on her legs and arms.
And did you talk to the mom about what you saw and what she was going to do about it?
It wasn't really a conversation, but I did ask about it.
Okay. And what happened after that?
Well, I immediately put him in counseling. I wasn't aware that they were going to counseling or getting any treatment at all from the mom. So I took it upon myself to put him in counseling.
What counseling did you put him in?
It's through online counseling, Spring Health.
Okay. And how long did that last?
It's still current.
Okay. And is there any cost involved in this?
Yes.
How much did you pay for a pre-session?
Well, we get 8 free per year, and then I believe they're $30 a session after that.
Okay. Are these costs covered by your wife's insurance?
Yes.
Okay. And what's the children's current counselor right now? Do they have counselors?
Yes. Jaslene's is named Jessina Tom, and Serena's is named Vanessa Navarrete.
Okay. And so you said they're still continuing this counseling?
Yes, they attend or they have a phone call, Zoom call once a month.
Okay. And since they started this counseling, have you noticed a difference in the children?
Yes, absolutely.
Okay. Now, even though they're still in counseling, are there any issues that you have with the mom continuing with having these children live with her?
Yeah, I mean, almost on a bi-weekly basis when I have possession of them, there's always some kind of issue going on where they're having a lot of anxiety living over there and a lot of complaints about their mom and how she treats them.
And do you bring this to the attention of the counselors as well?
I have in our initial meeting with the counselor, but I'm not aware of what conversations happened between the girls and the counselor.
Okay. So what's your attitude as far as the girls' conversations with the counselors? Have you ever sought any kind of involvement with them, or what has been your position?
No, I mean, whatever they want to tell me, but I let them have their private time with their counselor.
Okay. With respect to any therapy that the mother has for the children, has the mother ever asked you to participate in any therapy with them or any counselor with them?
No, she's not made me aware of where they were going and who the counselors are, or any treatments.
Okay. And have you physically taken the girls to any kind of other therapists other than the online therapists?
No, just online.
Okay. And regarding your wife that you've seen, how's the kids' reaction to your wife as far as them spending time with her?
They have a great relationship, very open. They talk about a lot of things. She helps them with a lot of things as far as being young girls growing up and preteens and being teenagers, helping them with their relationships at school and their school subjects. And
do you believe that the change of the mom raises an issue regarding changing schools and friends? What's your position as far as change schools and friends versus your position that you want to have full custody?
Well, as far as changing schools, I mean, they've changed schools 5 or 6 times since kindergarten, so there hasn't been any consistency there. But if things were to change, I would let them finish out their school year and probably move into a different school that has the same, if not better, opportunities.
Okay. All right. I'll pass the witness, Judge.
All right, state. Thank you, Judge. Again, it'll be really brief, but quick question. If you're asking the court to award you primary custody,
yes,
would you be requesting mom pay you current child support?
Yeah, sure.
You're in agreement with mom continuing to provide the health insurance to her employer?
No, I would probably put them on my own personal insurance.
You have it available to you through your employer?
Yeah, through my employer and also my wife's.
Okay. Is that medical and dental?
Yeah, medical, dental, vision, and
You
mental
want,
health.
I'm sorry, I didn't hear the last part.
Medical, dental, vision, and mental health. Yeah.
Okay. And you understand that the Office of Attorney General, we filed an intervention in the case specifically requesting a judgment on the child support arrears that are still owed on the case. Do you understand that?
Just now being made aware.
Okay. Essentially, we're requesting a judgment, but the difference between our request and what mom filed and her requested relief would be we request 3 separate judgments, meaning for your child support as one judgment, the medical as a separate judgment, and the dental support as a separate judgment. You understand that?
Yes.
All right. And so for your child support arrears, again, we're requesting the $666.26. For the medical, $556.58. And for the dental, $95.17. Are you opposed to any of those amounts?
No.
Okay. I'll pass the witness, Judge.
All right,
I have a couple more questions, Your Honor.
go ahead.
Okay. Mr. Bravo, when did you first notice your daughter's the scars or marks that you mentioned?
It would have been the summer of 23.
The summer of
2023. Yeah.
And were you aware that mom had the girls in counseling at the time?
At the time, no.
And when did you put the children in counseling in relation to seeing the marks?
It would have been the following couple days, maybe a week later.
And how were you able to do that if mom had exclusive and psychological decision making?
Well, I wasn't getting any answers or information from her about putting them in counseling, so I took it upon myself as their father to do what's best for them.
Okay, no further questions.
All right. Anything further for this witness?
No, Judge, unless you have any questions, Judge.
Attorney Franklin, anything further?
No, Your Honor.
All right. Attorney Hardage, you have 4 minutes and 52 seconds left. Attorney Salazar, you have 6 minutes and 12 seconds left. Attorney Franklin, you have 16 minutes and 59 seconds left. Attorney Hardage, you may call your next witness.
I don't have any additional witnesses, Your Honor.
All right, you rest?
I'm going to cross-examine Ms. Ortiz, but yes. I'm going to cross-examine Ms. Ortiz, but yes.
Okay. Attorney Salazar, you may call your first witness.
I'll call Miss Anna Ortiz.
All right.
Hi, Your Honor.
Hi, you all can go ahead.
Please state your full name.
Anna Ortiz.
Ms. Ortiz, so what is your employment?
I'm a Dallas County Family Court evaluator.
Okay. And how long have you been an evaluator?
Since April of 2025.
Okay. And you had an opportunity to be an evaluator in this case involving the children in this family case?
Yes, sir.
Okay. And were you personally involved in the creation and the recommendations that are contained in the Family Court Services Child Custody Evaluation, which was submitted to the court?
Yes, sir.
Okay. And
I need to make a correction that I've been employed since 2024, April 2024.
Okay.
Mm-hmm.
Thank you. And this evaluation was submitted to the court on about April of 2025. Is that right?
That's right.
Okay. You made several, in part of your investigation, you were able to interview both parents.
Yes, sir.
And you were also able to interview the children with the parents and also separately. Is that correct?
Mm-hmm.
Yes.
The observation was not quite an interview, it was just an observation, and then I interviewed the children individually.
Okay. Now, your recommendation after these interviews and your further investigation through all the other sources, can you please tell the court why you recommended that the father have the exclusive right to determine primary residence for the children?
With the understanding that Jasleen, being age 12, and her younger sister, at the time age 9, did not have a strong preference for either parent, but it did appear that in their best interest, they, based on some of the reports that they talked about mom, a lot of the mental health issues that are present in this case, school being affected, and conversations with their teachers, lengthy conversations with their teachers regarding very strong concerns, including having to contact CPS regarding their health and mental health when in contact with mom, and the children's reports. All of those things together led me to that. But I do agree that the children need both parents, as well as the stepmother.
Okay. And you find concerning that the mother has denied any the issues regarding that were brought up by the children? Do you find it concerning that the mother would deny and maybe say those are lies?
I do, because in our lengthy interviews, joint interview and individual interviews with each parent, she, as I said in my report, that she herself reported and self-reported mental health issues, diagnoses, anxiety and depression, previous abusive relationships, personal, family interpersonal problems, and denying that the children reported these things. As you know, Judge, the children are aware that they can answer or not answer some of these questions, and they appear to be very genuine, very sweet, very intelligent young ladies, and very self-aware, and even requested more therapy with me, which not possible, but I am glad to hear that they're continuing their therapy. But I do find that concerning, because that's something that has come, I think, out of the entire situation, not just mom.
Okay. And when you also investigated dad, you were also able to speak with stepmom. And what were your conclusions and findings regarding stepmom's involvement with the children?
Very involved, very genuinely loving towards the children. I believe they have a very great relationship, very close relationship. The girls both, huge smiles on their faces when talking about Mashika, and just a very loving home.
And your recommendation is for mom to have expanded standard visitation, is that right?
Yes, sir.
Okay. And have any of these other recommendations that you did changed in any way since you submitted your report?
No, sir.
Okay. I'll pass the witness, Judge.
All right. Attorney Hardage?
Yes. In your report, one of your concerns was Bianca's mental health. Is that correct?
Yes.
However, she told you that she sees a therapist and takes medication. Is that correct?
Mm-hmm. Yes.
And you did not speak with her current therapist before finalizing your report, did you?
No, ma'am.
And you did not conduct the psychological evaluation yourself. Is that correct?
Correct. It was provided.
So you relied on the psychological evaluation from 2022 that was prepared for a different legal case. Is that correct?
Yes.
And in your report, you described Bianca as emotionally supportive, loving, and deeply involved in her children's care. Is that correct?
Correct.
And would you agree that those are strengths that reflect positively on her parenting?
Absolutely, yeah.
But in your recommendation, you didn't give those strengths a ton of weight. Is that right?
Correct.
And you also reviewed CPS records during your evaluation. Is that correct?
Yes.
And in regards to reports involving Bianca, you listed a single ruled out CPS case involving Bianca in your report. Is that right?
Correct. There was another with an alternative response related to the children.
But that wasn't listed in your report. Is that right?
It was listed under the CPS, but possibly not under the Holly factors, if I'm looking briefly, but it is under the collateral section for CPS.
However, in your concerns about mother, you specifically noted that the school has had several CPS cases open against her. Is that correct?
Correct, because of those two. So when I list concerns, yeah, I don't obviously focus on the ones that would affect the children presently.
And despite the allegations being ruled out, you still listed them as a concern in your report, is that right?
Correct.
And you also received documentation about a 2022 CPS allegation that David and his wife locked the children in a bedroom, is that right?
Correct.
And can you explain why a ruled out CPS case was listed as a concern for Bianca, but another, ruled out CPS case was not listed as a concern for David?
I believe I'm not aware of, I'm not recalling the date on that. I don't know if it was more recent.
Okay, and you recommended that David be given the right to designate the children's primary residence, correct?
Correct.
And before this case, David had never been the children's primary caregiver, had he?
Only when the parents were together.
And in your report, you also noted that David reported a history of marijuana use, correct?
Correct.
2 minutes, counsel.
Okay, and you accepted his statement that there was no current use at face value, is that right?
I had not received any other, I was not aware of the failed drug test at that time. So yes, at that point, yes, it did.
Okay. So you didn't require him to undergo any substance use assessment?
Not in my recommendations, no.
But would it be concerning if a parent was frequently using marijuana in the home?
Absolutely, yes.
And Mr. Bravo didn't seem to indicate that this was relevant?
He didn't indicate that it was ongoing.
And by contrast, Bianca's mental health, which she was very open about, was treated as a concern. And then Mr. Bravo's, substance use was not. Is that correct?
With lack of police reports or any other documentation or proof of that, I did focus more on the mental health, which I've had a lot of collateral information on and self-report on, as well as the children. And like I said, references and teachers.
And how many teachers were you able to speak to?
I believe one was a written, and then Jaslene's was on the phone.
And did you include that information in the report?
Yes, ma'am.
Okay. No further questions.
All right. Attorney Salazar, Attorney Franklin.
I don't have any questions of this witness, Judge. Thanks.
Okay. Attorney Salazar?
Just briefly, did the mom raise any issues during your interview regarding any suspected drug use or anything like that that could be affecting the father's parenting?
I do not recall, but I do believe so. If I can briefly go through it, but off the top of my head, no. The father self-reported, but the mother's concerns I don't think were drug related.
Okay.
Just looking through.
All right. Thank you. That's all, Judge.
All right. May this witness be excused?
Yes, Your Honor.
Yes, Your Honor.
All right. Thank you, Ms. Ortiz, for your time here today.
Of course. Thank you, Your Honor.
Welcome. Attorney Salazar, you may call your next witness.
I'm ready to arrest and close, Judge.
All right. State?
Judge, ready to arrest and close as well.
Okay. Attorney Hardage, you may proceed.
Oh, I have no further witnesses.
Okay, well, you have 25 seconds left.
I'm good.
All right, Attorney Salazar, you have 1 minute and 51 seconds.
Thank you, Judge. In closing, Judge, I think Ms. Ortiz's testimony kind of sums up the issues we have regarding my client's concerns with mom. During my questioning, I asked her several different times regarding any issues on mental health. And she would not reveal any of the issues, even regarding, she didn't mention past relationships, more implying that it was my client's fault. I think through this investigation, it's shown that she cares more about her image and what's better for her than the concern and welfare for the children. When the children are reporting to the Family Court Services investigator that they have issues with mom yelling at them, physical abuse. Mom sits back and says, well, they're lying. It's not true. But the reality is that these children are suffering in their current situation where they need a more stable place to be able to live and to have support from a parent and even a supporting step parent. And that in this report, they've expressed that they would like that. It's not that they don't want to be with mom. It's just the issue that mom is not providing that support that they need, and that also of not interfering with their ability to have their own thought process and to be able to have an escape to do when mom is asking them, what did you say to the interview? What did you do this? Why? I mean, that's not productive to the child, and it objectifies the child to feel that this is going to be their fault in the future, whatever happens. And that's not what that's not what it should be about. So that, and for a lot of other reasons that are stated here in this report, Judge, we're asking the court to grant it. My client has indicated he's willing to keep them able to finish the school. It was not disputed that in the last 5 years, they've had 5 different schools. Mom didn't come to she didn't.
Counsel, you're out of time.
Thank you, Judge.
Thank you. Attorney Franklin?
Thank you, Judge. Judge, the Office of Attorney General, we're seeking just the arrears, a judgment on the child support arrears as of December 31st, 2025, in the amount of $666.26. A judgment on the medical arrears of $556.58, and a judgment on the dental of $95.17. Judge, the state will request payouts of $50 a month on each of those. And again, that judgment date would be December 31st, 2025.
All right. Thank you. Is there anything further?
Not from the state, Judge. Thank you.
Okay. The court has a couple of questions. Ma'am, what was your issue with Mrs. Bravo calling the school?
It wasn't necessarily calling the school, Judge. It was. I
mean, contacting the school, excuse me, contacting the school.
Oh, yes, ma'am. So she contacted my daughter's teacher via Class Dojo. My daughter, based on good merit and grading, she was selected to be a part of the car line team at the end of the day, which she was super excited about. And his wife contacted the teacher saying that she was not allowed to do so because it didn't work with her schedule, that she was not informed about it, which I did contact David to let him know, that we're so proud of her and please encourage her. She told the teachers that moving forward, any communication needs to go through her, and that my child is her child and that she has the only right and say. So that was the thing that was most concerning to me, was that she wasn't taking into consideration what was best for my daughter, because as we know, when they're more involved with school activities or extracurriculars, they tend to do better in school. But just taking that away based on whatever her needs were, definitely was disheartening. And then having to have that conversation with my daughter that she wasn't going to be participating because Ms. Shiga didn't want her to.
Okay. Was it, you're saying she didn't want her to, that's just what you're saying? That she didn't want her to, or could it be that it just was a conflict with scheduling for her because she does pick up the children?
No, and talking to my daughter's teachers, all Ms. Shiga had to do was stay an additional 3 minutes, and she refused. And my first daughter gets picked up around 3:30, so she would have been done. She gets done at 3:20, so she would have ample time. And then my second daughter gets out around 4 o'clock, so she would have had between
30 to 40-minute time frame. And my second daughter, her school is only about a minute or two from where I got it mixed up. Sorry. My elementary school and the middle school they're only about a minute or two apart. So that it was not a conflict of any sort. It was just what she wanted, and she did not want that for my child. I made it very explicit in the messages between her and my daughter's teachers.
Okay. Have you had an opportunity to read the custody evaluation?
Yes, Your Honor.
Okay. Something that the court found concerning was specifically from both children. Let me find the page. I want to say it's around page 15 or 6. Is it? It's amazing when you're looking for something, you can't find it. But your oldest daughter reported that you disparaged dad and stepmother on a regular basis. And then the youngest almost mirrored what she said. I'm trying to see if I can find her exact wording. Hers may be easier because it was italicized.
Interview with me or interview with children? Or no, was it at the interview with me, or when does it the interview with
the 9-year-old recalled on page 17, second paragraph. She is aware her parents do not talk to one another because they do not get along. She reported that her mother speaks negatively about her father and stepmother often. She recalled hearing her mother say that her father was not a very good person and that he was kicked out of the army. Did you tell your daughter that?
No, ma'am, I would never.
Okay, so the court, the court has issue with the children reporting something, and then you're coming to court saying that you never said it. So it's either the children are being untruthful or you are being untruthful. So I'm giving you the opportunity to say which one is it? Is it that your children are not telling the truth, or is it that you're not telling the truth? Because these children are different ages. They were interviewed separately. And they said almost the same thing, not that specifically about him being a bad person, but both of them reported that you speak negatively about dad and stepmother, and that they, saying they is father and stepmother, never says anything negative about you all.
I understand, Your Honor, and I have read through it, and I am disheartened that at that time frame of when my children were interviewed, that was at the peak of when David and I were, when there was a lot of domestic violence happening. I do know when others were involved, such as his wife or my mother, the information was shared with them from him and his wife to my kids, so that when the conversations that I'd have with my mother about certain things, my kids were around.
Yeah, they talked about that too, that you and their grandmother argue frequently. So I'm going to ask the question again because maybe you missed it. Are the children being untruthful, or are you being untruthful? Because somebody is not telling the truth.
I'm going to tell you that I have never said to their kids that their dad is anything negative. However, I have said things where we don't get along. We struggle with co-parenting. There is a reason why we do have counseling with Genesis specifically. I do want them to feel like they can advocate. I do want them to recognize, when abuse is happening. I have said those things. Yes, Your Honor.
Okay, so you do realize today, at least, that some of the things you have said to your children are inappropriate.
I apologize.
They can advocate for themselves without you saying anything about dad, and saying things like recognizing when abuse is happening. For a child, you're almost making them believe that something is wrong with their dad without saying it. I'm a parent too. So I have to be careful what I say, especially around my 6-year-old, because she interprets things a lot differently than an adult would. So what I'm not saying are the things that I am saying. Does that make sense?
You're absolutely right. Because as an educator, I do understand that the way that I engage in any conversation or engage with whatever related topic there is, that I have to be more intentional. And you're absolutely right.
Okay. And then your youngest daughter also is concerned, like these were her words, that you put a lot of blame on dad when a lot of it is you. This is what your children are saying.
I know. I know what it is that being said, but also, Your Honor, we do have to, for some reason, and I don't know why, for some reason, it was not added on there, the reasoning behind why my children and I have sought before all of this, initial support from counseling because domestic violence is happening. So we do also have to consider that my children are being, manipulated and weaponized in a way that they don't understand, just as much as they don't understand like the things that I say and take things in a different context. The same thing with whenever they're with dad, when dad manipulates the situation, makes things more chaotic, so then they feel that they have to, interpret it and,
where are you getting that from? Where are you getting manipulated? You use very specific words, manipulated and weaponized, because the report that I'm reading, that's essentially what they're saying you're doing, not dad.
I know.
And you said something else about, things being in the child's best interest. You said this earlier on when you were talking about your daughter and the reward she was able to receive from school. So clearly you understand things in her best interest. They love their stepmother. You don't believe it would be in their best interest to have a healthy relationship with the both of you, and referring to her as mom doesn't make you any less of mom?
I would love to be able to have a co-parenting relationship with her. However, when I have reached out to her prior to, she called me some inappropriate names. Just recently, she was trying to start a fight with me for no reason during the exchange. It is though they have created some, animosity and vindictiveness against me when I really want to try to co-parent with them. But you also have to remember, Your Honor, it is difficult to co-parent with an abuser. And I really am saddened that the evaluator didn't take the initiative to make sure that that was in the evaluation, because that was the whole intent behind it.
Okay, so as far as the court concerned, you all are joint managing conservators. Okay, so and for the modification purposes, and I'm not saying that whatever you're saying didn't happen to you. I'm not trying to discredit it. What I'm saying is by law, you all cannot be joint managing conservators if abuse has occurred. You all are joint managing conservators. And I can only go off of the history of the file because I've read everything all the way back to you all's underlying court order, okay? The one that's currently in place. And it seems like these girls would be happier and would be much healthier mentally if you were not doing some of the things that you are doing. And I'm not saying that dad is perfect because nobody is perfect. None of the parents on this Zoom are perfect. However, when you do things to kids to make them think that one parent is bad and the parent that you're trying to make seem bad is remarried, and you're also trying to make that person seem bad when they have a good relationship, you are contributing to the failure in communication and co-parenting. And as the judge, I have the task of making sure that I make rulings that are not only founded in the law, but that are in the best interest of the children. And based on the history of this file that I'm looking at, I do not believe it is in the best interest of the children for you to be the primary conservator, because as the primary conservator, I have to believe that that person that I designate as that is going to be the best to facilitate the co-parenting relationship. And I do not believe that is you. So what the court is going to do is the court is going to flip custody. The children are going to live primarily with dad, and they are going to do the expanded standard. And I believe that's in their best interest because the girls said that they want to be with the both of you equally. They are saying to me through this report that they love both of their parents and they do not like the breakdown in communication. They essentially don't like being put in the middle. That's what the court is going to do today because that is in their best interest. You all are not to disparage each other at all in any form or fashion. The co-parenting app is there for a reason. It's there to assist you all, not for you to be codependent on it. That defeats the whole purpose of co-parenting. So, and I'm not going to order that these children do not call stepmom, mom. I personally don't even like using the word stepmom because you both are parents. Everybody is a parent. Anyone who takes up the parental role is a parent. I don't think that's in their best interest to do that to them, to take that away from them. They have a good relationship with stepmom, with Mrs. Bravo, and the court would like to see it flourish. That's healthy for them. Let me go back to the recommendation. I am going to grant father's request to order you to pay child support. Father is also going to have the right to designate the schools that the children go to. If I heard correctly, the children are going to finish out the school that they're in now, and they're going to start another school in the fall. It shouldn't be an issue because his testimony was that they've changed schools frequently. There was no objection to that. There was no questions asked to anything contrary of that. The court is going to order that the children continue in counseling. I think it's in their best interest. It also wouldn't be a bad idea if you all attended some sort of family counseling together. Because at some point you and Mrs. Bravo are going to have to work together. She is extremely involved. Based on the information that I heard, she is extremely involved in your children's lives. And you definitely want to have a relationship with someone who is that involved in your everyday life of your children. No physical discipline of the children, either parent. Do the children, well, at least the oldest child, have a cell phone?
I believe so, Your Honor, on the mom side.
Okay, mom, are you paying that cell phone bill? Okay, Dad, if you want to get the kids a cell phone, you're more than welcome to do that. I'm not going to order that the children speak with either parent when they're with, like when they're with you, if they want to call mom, let them call mom. They're old enough, right? But I'm not going to order anyone to do that. I just think that sets you all up to get you into more issues, and it's really not worth it. If you have to make a report to CPS, just make sure you all are doing it with good faith basis. Do not use CPS as a weapon. That's definitely not going to work with me in court. I also grant the recommendation from the state, the judgments as of December 31st, 2025, medical support judgment in the amount against father in the amount of $556.58. Dental support judgment in the amount of $95.17. Child support judgment in the amount of $666.26. Each of those are at $50 a month, sir. So if for any reason you're able to pay them off quickly or at one time, however you want to do it, that will fall off. Okay, you'll be done with that.
Okay.
And sir, I am going to order you reimburse mother $310 for that drug test.
Okay.
I am also putting an injunction in place that neither parent is to use illegal drugs. And that just doesn't go for today's court session. I mean, drugs are illegal, so don't use drugs. Mom's financial information. State, do you all have that?
I don't think we do, Judge. I'm looking now to see, confirm. Give me one moment, Judge. We may have it.
Oh, no worries. Dad, is there going to be any issue getting the children to school in the mornings?
No.
Okay. Because that, my ruling starts today. It doesn't start for the next school year.
Right.
Primary, you're now, the children will be living with you primarily. Mom will have expanded standard.
Okay, understood.
And you all will follow what the Texas Family Code says about the holiday schedule. Your attorneys can explain it to you.
Okay.
And one of the children has a birthday coming up, right? February 10th?
Yes, the oldest.
Okay, so on that day, according to the Texas Family Code, mom is allowed 2 hours and she gets both kids on each child's birthday, she gets both kids. Now, it says 2 hours, but if you all come to an agreement to do something different, you're more than welcome to do that.
Okay.
Did you mention about the parenting app? Is there a specific one? Because I think we had requested maybe switching to Our Family Wizard, but I'm not sure. Because I think AppClose started charging or something monthly.
Oh yeah, they did. AppClose is a good app though. Although they started charging, and I believe it's still cheaper than Our Family Wizard. So AppClose is fine.
So, Judge, we do have her income information. It's only for the last 3 quarters of 2025, though. We don't have the 4th quarter of 2025 yet.
Okay.
So I can base it off of those 9 months, but it may come out a little bit more than what she actually makes. Because based on the 9 months, we have the monthly gross is $59.49. But again, this is only 9 months. We don't have the last quarter reported yet.
Okay.
I can calculate it based on that if I just get testimony as far as the health insurance and what that would be.
Okay, let's do that. Yeah, you can go ahead.
Okay, just to ask you, Ms. Bravo, so you have the health insurance through your employer? Oh, you have to answer out so I can.
Yes.
Do you know how much it costs you per month just for the child's portion?
Right now I'm paying, it just increased to 455. So if you divided that by 4 and then added 2, it should give you how much you make.
Gotcha. Okay, because it's 4 people on the plan.
That's right.
So that comes to about $226 a month for the health insurance. And do you have any other children under 18 besides the 2 in this case?
Yes, I do.
How many other children
I have a 4-year-old. I have one.
that lives with you?
Yes.
Give me one moment. So Judge, the child support at 22.5% would be 1,056. Again, that's based on a monthly gross of 59.49. And giving her credit for the health insurance at 226 a month.
Okay. So this what we'll do. We'll set it at 1,056, considering that's all we have at this time. Attorney Hardage, when your client gets her W-2, if she would get that to the state, and then we can get the child support adjusted accordingly, that would be great.
Yep.
All right. Is there anything further for the record?
Nothing further, Judge.
Nothing further.
All right. So how long, Attorney Hardage, do you need to prepare the order?
Can we get the standard 30 days?
Well, that's not standard in here.
Oh, yeah, whatever you think is appropriate. I'm sure I can get it turned around pretty quickly, but.
Okay. Hold on 1 second. Let me go look. February 6th or February the 13th?
Can we do the
13th, Judge. 13th.
13th, yeah.
13th is cool. Okay. So I will set you all on a dismissal docket for the 13th. If for any reason you all cannot, or if there is any reason that you are you're not able to get the order circulated or whatnot to get it signed off on by the 13th, you'll only get one more reset after that.
Okay.
And that's it. Okay. However, if you are able to get it circulated and signed before the 13th, just submit the order to my coordinator.
Okay, sounds good.
Okay.
Thank you, Judge.
Well, you're welcome.
Thank you, Your Honor.
Were
You're
we
welcome.
excused?
Yes, the 5 you like.
Yeah, I guess so, Linda. That's it for today, ladies and gentlemen. I think we kind of dragged this on a little bit. I was kind of late because I said I wanted to sleep in. But that's it for today, ladies and gentlemen. Tomorrow is our body cam footage, so I look forward to that. For now, ta-ta and ciao-ciao. You all have a wonderful, wonderful evening, and I will see you again soon.
You stare in the mirror longer than I do. Must have been delulu when I fell for you, but I couldn't help. You were such a mood, sucker for a neck tattoo. So full of yourself, low key you need even care anymore. Happy